Good afternoon. Welcome to Law Power Hour. I hope all of you had a good Thanksgiving. Today we have the pleasure of having Mr. Peter Wall with us. Peter, thanks for coming in.
Hi, Mr. Keller. Good to see you.
Peter Wall is a very interesting lawyer. He practices workers' disability compensation law. His father was in this field for many, many years. He was a notable, and we loved him. We miss him.
Yeah, thank you. Appreciate that.
And Peter has taken up the mantle. He has a law firm in Northwest Detroit, covers the entire state doing workers' disability compensation.
That's true.
Peter, what's going on in workers' comp today?
Oh, these are tough days for the injured worker in the state of Michigan. As you know, your governor is not a real friend of the working man. He kind of treats people when they get hurt at work like people living in Flint and drinking water. So it's a tough day if you're getting hurt at work, and that's what I do. I try to help people when they get hurt at work,
Peter,
exclusively.
Peter, I have to interrupt you.
Yes.
He's the elected governor of the state of Michigan. You don't let the audience think that he's my governor, because I didn't vote for him, nor did I embrace the governor's policies.
I
He's hurt all of
apologize.
us. Okay.
I apologize. No offense to anybody out there. Just talking about his policy with regard to work comp. People get hurt at work. He's not.
Now, isn't it true under the present administration, and I'm talking about the present administration in Lansing, that we've suffered some of our worst losses, and that is not losses in the courtroom, but losses as a result of the legislature changing the definition of disability?
Absolutely. It would appear that the legislature and the governor seem to be employed by the Chamber of Commerce in the state of Michigan. They've changed the definition as far as when people are entitled, when they get hurt at work, to receive weekly benefits until they're able to go back and earn a wage. You got to remember, workers' comp is to get you, so you can eat, so you can live, keep a roof over your head while you get better to go back to work. It's wage loss. It's not damages. It's not pecuniary damages or anything like that. It's to get back to work.
Well, one of the segments during the hour, we're going to talk about whether you can sue your employer directly
Yes.
for various types of injuries that may occur at work. But at the present time, what we're talking about this, basically, tell our audience what you have to prove in order to make a claim for workers' disability compensation.
Let's say a person gets hurt at work. If a person gets hurt at work and they can't earn their money or do their job, your employer has two choices: either give you something you really can do, or pay you wage loss until you're able to go back to work. And it used to be the job you got hurt working at, if you couldn't do that job, they were supposed to pay you or give you something you can do. Governor Schneider, or the recent administration, has opened it up to not just the job you got hurt working at, it's any job out there. Regardless of whether it exists or not, you have to look for a job in the community, not the job where you got hurt working, which is how it used to be. You have to show that you can't work anywhere now. So insurance companies are interpreting that and keeping the money, keeping the premiums from these companies, and not paying anything, because they're going to pay someone to say that you can work someplace regardless of whether you can or regardless of whether the job exists or not.
Let me see if I can interpret this, and maybe you can help me along with this process.
Yes.
If I'm a millwright and I'm working in the factory in the skilled trades,
Yes, sir.
I'm earning $35 an hour, which is about the going rate for millwright today.
Yes.
And I can't do my job, and I get hurt, but I can take another job where I can work at McDonald's, for example. And I can do a job where I stand for 7 out of 8 hours, work at McDonald's, but I don't have to lift anything heavy because I hurt my back at work as a millwright.
Yes.
Do I have to take that job if it's offered to me?
You can, if you're an insurance company, you are going to argue and not pay the millwright, because they're going to say that you have to go out and get a job and mitigate or try to lessen the damages and try to earn something while you're off work. The governor seems to think that a person has to actively be looking for work, even if they're disabled, to be entitled to benefits. We're kind of up in the air of whether or not a millwright who earns big wages has to look for jobs with his injuries, making as much money. But the way that's a new thing. They're going to fight that. My argument is, if you have to get a job at McDonald's and you're making a lot less money, then you shouldn't have to, and they should have to pay you the wage loss from the millwright job.
Now, recently, and I understand that you keep up with the workers' compensation law weekly.
Yes, sir.
I understand that there was a new case that just came down from the Michigan Court of Appeals dealing with the specific issue of what type of work you had to go out and look for.
Yes.
I want people out there drawing workers' comp now, being forced to look for jobs, to remember to call Mr. Wall after he tells you what the change in the law is, or tell your friends and family about this, because it's really important change.
This is an important change because people who are paid work comp have been cut off from their benefits before before they're able to earn a wage, because they didn't go and look for a low-paying job. Currently, the Court of Appeals has indicated that a person doesn't have to look for jobs making less money. The case is about a guy who's making a lot of money as a lumberjack up north. And guess what? They make a lot of money, and there's no other jobs up north than to be a lumberjack. The Court of Appeals says that the guy only has to look for work making as much money as he did as a lumberjack. So a lot of people out there, a lot of your viewers, I'm sure, have been affected by this, have been paid work comp, working in high-paying jobs, because the insurance company says they're not looking for work for like the McDonald's job or the low-paying jobs, and they've been denied on that basis. I'd like to challenge those denials. That's why I want people to call me up.
Give me your number.
I'm going to give you my number. It's area code 248-352-3433.
And if you call my number, I'll refer you to Peter.
Absolutely.
Now, I want to go through the mechanics of the workers' comp so our listeners understand how this really works. You file an application for benefits, correct?
Yes, sir.
That's when you've either been denied your benefits, there's been a dispute filed in your case.
Sure. Well, after a person gets hurt at work, you got to tell your employer that you're hurt. And the employer is supposed to be the one submitting it to their work comp carrier. When you don't hear anything and you're sitting home and they're trying to forget about you and you're floating out in space and no one's paying you anything, that's when I want you to call me. They want to forget about you, and I guess a portion of the people just go away and don't do anything about it. So when a person gets hurt at work, the employer is the one who's supposed to report it. When they don't do anything, when they don't give you a job you could do, and they don't pay you, is when we sue them.
Peter, there are time limits that are important here. If I get hurt at work and I tell my employer that I've been hurt at work and they turn it over to the insurance company, and the insurance company gets a notice of dispute out to me saying, look, I'm disputing your injury, how long do I have to file a case?
Well, there's what's called, you actually have a 2-year, if you're never paid workers' comp, 2 years, you have 2 years. It's called the 2-year back rule. It's not a statute of limitations, but I can only go back to try to recover anything from 2 years prior to the filing of my petition. If you are paid, you only have a year to recover anything going back. A 1-year back rule will apply. If they don't pay you or they deny it, then you should call immediately, because we know where they're coming from. They're not going to pay you. You're not going to get a check. Notice of dispute means we're not paying you. That's when you need to take action.
Now, what's really important, though, isn't there a 60-day provision?
When a person is paid benefits and those benefits are terminated, there is a provision under the law called the 60-day rule, where you may have a hearing within 60 days of having your benefits terminated.
So there are ways of advancing your claim if you call people like Peter Wall, if you've been
Yes.
paid and you're cut off your benefits. Now, let's take this whole process and dissect it. Cut it up a little bit into pieces here.
Sure.
You file your application. You've got medical.
Yes.
You submit your medical. The insurance company sends the client out for an examination, right?
Absolutely. Usually the insurance company are going to use their own people. And you can imagine who the people are that they're using, these physicians. I call them vendors. They're paid to give an opinion with, the best interests of the insurance company in mind, because they're paying them. One thing that I should point out, when you get hurt at work, it used to be you can go to your own doctor after being off for 10 days. Governor Schneider and the new administration has changed the law. They have a right to send you to their people within the first 28 days. So the company clinics are going to see you within the first 28 days, and it used to be 10. That is not something that's sympathetic towards an injured worker because they're going to pick where you go.
Here's the biggest gripe I have when people call me on the phone. This is what they're telling me. Hey, I got hurt at work. The insurance company assigned a case manager to go with me to the doctor. Do I have to have a case manager?
That's a very good question, and hopefully you understand that the case manager, I call them the spy for the insurance company. They're not there in your best interest. My policy is if you're not receiving workers' comp benefits, then they're not allowed to send a nurse case manager anywhere. If they're paying you, you're kind of going with the flow. You're kind of understanding that they're not there in your best interest, but you don't want to disrupt your benefits or interrupt your benefits. So you're going to kind of cooperate with them, and you're not going to let that person meet with the doctor without you there. Or some people don't like with that person coming in to see the doctor with them. I've had that happen a lot.
Okay, now after 28 days, can I go to my own doctor?
Yes.
Do I have to give notice to the insurance company?
You have to tell them where you're going. I would say yes.
So you have to send them a note and keep a copy of anything you send to the insurance company.
Verbal or keep track of who you talk to and send a note. It's a good idea.
Yeah, I always tell people to send a note,
Great
keep
idea.
a copy, because then you can prove that you sent the note and you've got a copy in your possession.
I think that's prudent advice.
Okay.
Absolutely.
Now, let's say you're being paid workers' comp, and you go to one of the vendor doctors, or I call them the hired guns, and they say, Peter, you can go back to work, but you've got some restrictions. You can't lift over 20 pounds. So they send you out to a vocational expert.
Yes.
Would you like to share with our audience what happens when you go to a vocational expert?
A lot of times they put people in a room with some want ads, and you're going to go through and look through the want ads and see what's out there. I haven't seen that too much lately. It seemed more prevalent earlier on. When the person who sees you on behalf of the insurance company, as you call them, the hired gun, puts restrictions on you, sometimes they have you come back to work and they say they're going to honor those restrictions. And usually I have my people go look and see what it is, and it's usually your old job, but they put the word restricted in front of it, and it's something you physically can't do. Also, his opinion with regard to what you can do or what you can't do, I'm talking about the hired guns, that's a big grain of salt. I want what you and your own treating doctor, who's not paid to give an opinion, who doesn't have any interest in your litigation, I want to know his opinion, and I want to know your opinion, what you can and can't do as far as returning to work.
Now, if the vocational expert says, Peter, I've assessed your education, your training, your background, and you're qualified for other employment, and here's a list of places I want you to go look for work. Do I have to do that in light of the new case that just came down from the Court of Appeals?
I'm going to say that the governor and the current case law require you to make a reasonable search for a job within your restrictions. And lately, a job that you can earn as much as you did when you got hurt. I think you have to show that you've put forth a good faith effort, a couple jobs a week, to try to get further employment. But the key with that is sometimes these vocational experts tell you not to talk or to say that you have a physical restriction. They want you to lie about it. So you're going to disclose that you do have limitations, work-related limitations, like you have a bad back or you have a bad shoulder, when you're trying to seek out this new employment.
Do we still have in force, and I only say this because I'm not kidding about it, it's very serious, do we still have in force the wallet card program? If you get hurt at work, you can go to the Department of Vocational Rehabilitation and get certified.
I'm not familiar with that.
Okay, well, we used to have,
Yeah.
through the Department of Vocational Rehabilitation, a wallet card program where you could get certified. So if you went to apply for a job, they would limit the liability of the employer, the responsibility of the employer.
That
Okay,
sounds great.
we're going to take a break for a couple of minutes. When we come back, I expect to have some calls come in here because there are a lot of major issues about workers' comp and Social Security and automobile no fault that are all bound together. So please call us.
Thank you.
Thank you.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
Okay, so Peter Wall drove over here in his car, and he's an employee of his corporation. So he was in the course of his employment coming over because he's talking about the law.
Right.
Let's assume for the moment that Peter Wall was involved in an accident on the way over here. Could you recover workers' compensation?
Workers' comp would be primary for my wage loss and my medical if I get into a car accident while in the course of my employment. If I'm on my way home after I leave, that is not the course of your employment if you're going home. If I'm coming in to my fixed location for work and I get in an accident and I'm not there yet, that may not be in the course of my employment. But coming here for my job could be, and I'm not going home, is, rising out in the course of my employment.
Well, we're not asking where you're going after the show, but
Right.
if you're going to see a client, you're still in the course of your employment, aren't
Yes, because I'm doing that for my business, yes.
you? Hold on for a second. We have a call.
Oh, great.
Good afternoon.
I have a question.
Hello?
Hello?
We can't hear you.
Anybody home?
You're not
Hello?
coming through, but we're here.
Oh, I got a question about part-time workers.
You got a question?
Yes.
Okay, well, they got to get the volume up so we can hear you. Somebody shut off one of the speakers in the studio here. We're
I don't
live.
know how to do that. Can you hear me now?
Oh, yeah, well, they turned the
Yes.
speaker up just because instead of having reruns on here, they've got two live folks here, so speakers are loud, we're ready to go.
Madness. If I don't work full time, I get hurt at the job. Well, do I get any type of payment for that?
Absolutely. It's based on you got to be an employee, and it's based on your wages. Full-time, part-time, you would get 80% of your average weekly wage. If it's not full-time, it's 80% of your part-time wages, sir. Yes, part-time workers would be entitled to work comp if you got hurt at work, yes.
Oh, okay, because I was unaware.
Yes, sir.
Well, thanks for that, sir.
No problem.
Thank
Call me.
Oh, okay.
Call the
Thank you.
show. Yeah,
Thank you, mister.
thank you.
Okay, thank you. Just on that note, if you're a part-time employee and you have an exchange of services, your employer says, hey, Peter, I'm going to work you 30 hours a week. I'm going to pay you for 20, and I'm going to give you a free place to live. If I get hurt, does the value of the rental come in as part of my wages?
That's an interesting question. I mean, it is based on taxable wages, and a lot of people are paid other than with money. But there's a certain, complication in trying to figure out how to put a value on how much your rent is, but it's done. It's absolutely done.
I guess we opened the door to another question. Good afternoon.
Hello?
Hi, we're here.
Yes, I was injured on my job February 14th, 2014.
Yes, sir.
I had 750 pounds fall on top of me, released on top of me by my supervisor, who had who had injured his eye and really shouldn't have been on the floor, So, and he released this stainless steel tote on top of me because with the eye restriction, he couldn't tell how close I was to it, right?
Okay, he's a coworker, right?
Yeah, coworker,
Okay.
And so I went on a workman's comp, and I was off. I was off for 2 years, and I received workman's comp, and then they made a settlement with me, right?
You had a
And they
settlement.
gave me a lifetime restriction. Their doctors gave me a lifetime restriction of a sit-down job only with no lifting.
Yes, sir.
But, I still stayed with the company for a while while I was on workman's comp.
Yes.
But my lawyers was telling me that I was going to be able to get Social Security disability, but come to find out I only qualify for SSI, which is only like $795 a month, right? And so my employer took me back, right?
So you went back to work after you went off for being injured.
Right. They took me. They hired me back again, right?
Okay.
But the job that I'm doing, is way beyond my restrictions.
So you're still working now, sir, and you're making yourself worse.
Yes.
So when you get to the point where you physically can't do this any longer and you keep aggravating your condition and you go off work and it's because of your condition, then they're supposed to pay you.
My restriction is a sit-down job only and no lifting on my right extremity, right?
Yes.
But I'm doing a janitorial job where I'm constantly walking, and then they have me doing other stuff outside of that too.
Sure. So you're making yourself worse. You're not doing the restricted job. You're doing something else.
Right. But when I went in there, they made me sign this paper saying that I wouldn't sue them for any kind of injuries or anything.
Okay. So if you go off work and you aggravate it, you could still come see me because I could sue them. The only way you could sign off on your rights is through court. So if you have some private piece of paper that you signed to get back in there, that's not going to hold any weight in court. Mr. Keller, would you?
Right.
Agree?
I mean, I was severely injured. I had 4 surgeries. My shoulder, when they did the surgery on my shoulder, is irreparable. I got bone rubbing against bone. I broke my wrist. I had 2 surgeries on my wrist, and I tore my ACL and my MCL, and they had to take my meniscus out my knee, and then I'm doing all this walking,
Absolutely.
Well, right
so
now.
is there a way I can come in and talk with you?
Yeah, absolutely.
Yeah, well, let me ask
Okay,
you an
listen,
important
can you
question.
give me your number? Hold on. Let me find a pen.
I got Mr. Keller wants to say something.
Okay.
Did you work for this employer 5 out of the last 10 years?
Have I worked?
Yeah, have you worked there 5 years in a row?
No, I didn't work there 5 years. No, I was like 1 month short of the year before this injury happened. And I know that the law for Social Security disability, you had to work 5 years. But prior to working there, I worked for this company as a private contractor, and I didn't pay into the Social Security during that time.
So now you're an employee working there. You're not a private or independent contractor, are you?
Oh no. This is not. Huh? Yes, I'm an employee there. I've been back to work. I went back to work. I've been back to work like 9 months now.
Okay.
Well, you still would have a problem. You'd be eligible for SSI. You wouldn't be eligible, that Social Security supplemental benefit. You wouldn't be entitled to receive workers' comp. Now, you settled your first workers' comp case, correct?
Yeah, I settled my first workman's comp case, right?
Okay, I think you should come in and see Mr. Wall. You have a pencil now or a pen?
Okay, yeah, hold on. Let me get one.
Sure. Sounds like we have a settlement and a return to work.
And we might have a total and permanent disability now.
And a TMP.
Are you ready with the number?
Okay, yes, I'm ready.
Okay, we were waiting on you.
Okay, you ready? Call me in my office. Peter, last name WOLL, 248 352 3433.
3433.
Would you repeat that for our audience, please?
Sure, Peter, WOLL, 248 352 3433.
All right. Okay. I have
Okay, now listen, your visit's going to be confidential. He's
Yes.
not going to call your employer and say that he's filing a case. He's
Right.
going to help you plan your case.
it.
See,
Okay.
that's the biggest problem that people have, is that they don't talk to a lawyer when they have an injury and plan, P-L-A-N, their claims. If you
Yeah.
plan your claims, you get better advice.
Right.
I don't think our audience understands how much knowledge workers' compensation lawyers have to have. They have to know about Social Security disability. They have to know about automobile no-fault claims. They have to know about negligence claims if your employer's responsible for your injury, and workers' comp. So thanks for calling, and give Peter a call.
Yeah, I appreciate
Okay,
it. Look
let me
forward to
repeat-
talking
let
to
me
you,
repeat
sir.
Let me repeat the number back to you. Make sure I have it. 248-352-3433.
Yes, sir. You got it. Thank you.
Thank you.
Okay. Thank
Talk
you.
to you tomorrow.
Good afternoon. Welcome to Law Power Hour.
Good afternoon, twice. I want to ask the attorney, both of you.
Yes.
Since Snyder and the Republican legislature have been in place, has worker protections eroded?
It's been a
And
death
how,
knell.
If so, how are you dealing with it? That's my question.
It's for whom the bells toll. They've almost killed comp.
Yes.
I mean, they've done more to destroy workers' legitimate rights to benefits than any other legislative body in the history of the state of Michigan. They have done more to erode. The pendulum has swung in favor of the employer and against the employee across the board.
I miss Governor Engler. I mean, how about me saying that? I've been doing this for 27 years. If you look at the statistics as far as the judges that we have to use for workers' comp, they're not awarding benefits to the injured worker. It's racketeering. I hate to say that, but people ask me what can you do? Well, you got to vote. You got to get out there and vote the next time around for a Democrat.
You know, they changed the law on workers' comp to the extent that if you have to try a workers' compensation case today, it's almost embarrassing to go to trial, because if you have 100 cases that are being tried, only one of them is going to be successful.
It's true.
And it's a statistic that is absolutely true. You could go to the state of Michigan and look at the results for 2015, and you'll see, of all the petitions that are filed, the majority of them are settled for peanuts, for small amounts of money, because the employers have the upper hand.
There's no enforcement. You know, I used to be able to negotiate, because if you're not going to pay me, I'm going to have a magistrate who may make an insurance company award benefits. I don't have that enforcement arm any longer. We do the best we can. So how good a case is how, the severity of the medical that we're dealing with.
So thanks for calling in.
Yeah, I appreciate the question.
Let me take you back here for a minute before we take a break. We were talking about driving here in the course of employment, getting involved in an accident. And you say you're covered under workers' compensation. You're also covered under no fault. Who pays first?
Well, when you get in a car accident and it's not your fault, there's potentially 3 different cases. As far as workers' comp, am primary for the medical and the wage loss. Your car may pay someone to help you around the house, $20 a day, replacement services, and there might be a little bit over the work comp rate that the car's insurance is supposed to pay for. Excuse me. The person who hit you, that's the pain and suffering lawsuit. So I think the question was, who is supposed to pay first? Well, you're going to need the wage loss initially. Sometimes the medical is paid for and the wages are paid by the vehicle, and then a person who gets those benefits might have a lawsuit that they're part of that's filed by the insurance company from the vehicle to get paid back from workers' comp.
Now, am I entitled to attendant care under workers' compensation? One of our earlier callers, based upon his horrible injuries, more likely than not needed somebody to help him get dressed, undressed, feed, bathe, shower. That's attendant care, isn't it?
If you have a prescription for it, and it's like nursing to take care of your needs, I would argue that yes, workers' comp is supposed to pay for that.
And they pay the first 56 hours of it.
They are limited to 56 hours, yeah.
And then you can go to the no-fault carrier beyond that if you need it, can't you?
That's what my understanding, yes.
Right. Well, we're going to take a break for a minute, and then we'll be right back. Thanks for calling in, and keep them coming.
Thank you.
You know, there are other areas where an individual who's hurt during the course of their employment has a potential claim besides workers' compensation. For example, let's say I work for a bakery company and I'm delivering baked goods to a grocery store, and there are no mats on the floor and it's raining outside, and I slip and fall and I hurt myself, and they know that it's wet outside and they know the floor is wet when I'm coming in, can I sue the grocery store?
You know, as a workers' comp attorney, we're always trying to find something outside of workers' comp. Workers' comp is only wage loss. If your injury is because of a third party's, say, negligence, like, you know, you're on someone else's premises and they're negligent about, you know, the condition, and you're injured because of that, then you may have a case against the business owner outside work comp for your pain and suffering. So yes, I'm going to say yes.
Now, you're in a unique classification, though, because, you know, on premises liability, there are different classes of invitees on the premises.
Sure.
You're a business invitee, correct?
Yes.
And there's a higher duty owed to a business invitee than a social guest coming on your property.
Right.
So as a business invitee, there's a different standard of care, isn't there?
It's got to be safer, yeah.
Okay, for example, you're an electrician and you're an outside contractor and you get called in to do the electrical work on a building downtown that's being renovated by one of those business entrepreneurs downtown. And while you're in the building, somebody's up in a scaffold and a wrench falls off the scaffold. One of these big wrenches that they use, you know, for putting in a venting system.
Sure.
And that wrench hits you in the head.
Hopefully that is not a coworker. It's someone from a completely different company. And if there's another case against someone because he's not a coworker. He's a third party.
Okay, and you might have a case against the general contractor as well.
You might have, yes.
I mean, let's look at it in terms of layers of responsibility for a moment here.
Sure,
Okay?
Sure.
You could have a case against the general contractor.
Sure.
Okay, let's say I'm doing excavating work for the city, and I'm an outside contractor not employed by the city, and the city doesn't provide me with a safe place to work. Can I sue the city?
I'm going to say you may have a case against the city for negligence because if they're the property owner and they've done something where they've had you come in and doing work, that possibility may exist, yes.
So there are other possibilities.
As long as you don't work for who hurt you, yes.
Okay, now let's take it to the next level. I'm a press operator and I am operating the press, and the press was negligently designed by the manufacturer of the press. Do I have a claim?
Not against your employer, but possibly for products liability against the company or a maintenance company, someone other than your company coming in. And if they were, you know, messed something up in the machine and that's how you got hurt, you may have another case.
Now, you know, every night around 12 o'clock I see these commercials on TV for asbestos. And you know exactly what I'm talking about, and I'm not implicating anybody.
Mesothelioma?
Mesothelioma. It's like having a pancake on top of your lung.
Okay.
It really is. It's like having another skin on top of your lung.
Wow.
It suffocates you and you can't breathe. You can look it up,
Horrible.
Google it up. It's horrible.
Yeah.
So if you're out there and you have an asbestos claim and you haven't filed a workers' compensation claim, can you file a claim against your employer and make an asbestos claim as well?
I think that would apply, yes. I think there's a fund set up, certain fund set up that you might be entitled to money as well, yes.
So you'd be able to make two claims instead of one claim.
Yes, that's one of the few times that would apply. You know, another thing that comes up, Mr. Keller, is people that are temp workers and don't work for where they're placed in those factories. Unfortunately, let's say you get hurt and you don't work for the factory. For purposes of workers' comp, here's where where it's not desirable. For purposes of workers' comp, when you're a temp, it's like you work for the company you got hurt working at. So it's not a third-party case.
Okay, let me see if we can dissect this for a minute.
Yeah, it's interesting. It happens a lot.
I go to work, and I'll name them, for Manpower,
Yes,
or Mr. Quick Fix-It employer,
yes,
because I want to be fair to everybody.
yes.
And so Quick Fix-It sends me out on a job over at Peter Wall's, and I get hurt there. I can't sue Peter Wall, can I?
No, I'm not your employer. So no. You could sue your employer, who's Mr. Quick Fix-It, if you're an employee, but you can't sue me unless I intend to hurt you.
Well,
Are
suppose
you talking about me as a business entity or like a private
no,
home?
a business entity.
Okay. Well, you're not a temp. I'm not hiring you as a temporary employee in my business. So I'm going to say the economic reality test would apply here.
But there are circumstances where this occurs where you have to really be careful. If you work for a temp agency and they farm you out, let's say they farm you out to ABC Plastic, and if there's an ABC Plastic out there, I'm not making a claim against you. I'm just using the generic term ABC Plastic for our conversation.
Yes.
So if the temp agency has a contract with ABC Plastic and all the supervision's done by ABC Plastic, I'm really an employee of ABC Plastic.
Yes.
And the only purpose for the temp agency is to control the flow of employees.
Yes. You do have a comp case still against Manpower or whoever your employer is. But
Right.
not there's no third-party case because ABC is not your employer.
That's the point I want to make.
Yes, sir.
But on the other hand, if I get hired from the temp agency by ABC, who's my employer now?
The ABC.
Okay. Now let me take you to another level here. We talked about defects in products. For example, you're working on a press and there's something wrong with the press. Let's say that the press misfires
Fires.
and it stamps twice in a row and your hand gets stuck in there.
Sure.
Can I sue the manufacturer of the press?
Possibly. I'm going to say it's a product liability if there's a defect in design or something, which would, take it to the level of something having to do with the machine, and an attorney's willing to spend the money and to look into it. Yes. I don't see why not. Because you're not suing your company. You're suing a separate company that manufactured the machine or serviced the machine.
Now suppose my employer takes a safety appliance off the equipment and I'm injured. Can I sue my employer because I was injured through an act that my employer did in taking off a safety appliance?
Gosh, you think you should be able to, but I'm going to say no.
And tell our viewing audience why you can't sue your employer.
Unless they intend to hurt you. Unless they intend to hurt you.
There, get it right in there.
Okay, intent, meaning like criminal intent, like I'm going to hurt this guy, or it's just an accident, or it's negligence. It's still only workers' comp, and that's not fair, and it's not commonsensical to think that way. But I'm going to argue that it's still workers' comp unless they intend to hurt you.
Okay, now there are other exceptions to workers' comp, and let's talk about some of those right now. I harass you at work.
Yes.
You file a claim for workers' compensation, and there's an age discrimination claim, sexual harassment claim. Can I sue you under the Civil Rights Act and have a workers' compensation claim?
Yes. Yes.
And most folks don't understand that, do they?
No, they do not.
Can I sue you for emotional distress and recover for that?
You talking about a psychiatric injury?
Yes.
Yes.
Okay, so emotional distress would be compensable under the Workers' Compensation Act, provided there's an objective test. Is that correct?
It's got to be something, an actual, not an imagined, event which causes the problem. Okay, you can't just imagine someone doing something to you. It's got to really have happened.
Okay, let me give you an example, and this is kind of a crude example, but it will work. If you're standing in front of a press and you file a workers' compensation claim because you claim the press is talking to you, you can't recover, can you?
I'm going to say I'm not taking that case, and I don't think you can recover. Maybe back in the day you could. I don't think so.
Because we needed an objective test, correct?
Yes.
But if you're standing in front of the press and your employer pushes you into the press, can you recover?
Well, if he intends to hurt you, I think you can have a work comp case and an intentional tort case against your employer. Yes.
And things like this happen, don't they?
Sure. Absolutely.
In fact, just by way of example, remember those young folks who were sent down to work in a silo in Michigan?
No.
And there was an explosion in the silo?
Oh, yeah.
Yeah, they were killed down there.
Sure.
And they filed third-party claims against the employer.
Right.
You can do that, right?
Absolutely. You can
Okay.
file any case you can. Whether it's going to be a success is another story, but yeah.
Okay, now, hazardous substances in the workplace, we talked about asbestos.
Yes.
But if you're working with toxic substances in the workplace that make you sick, can you bring a lawsuit against the manufacturer of the toxic substances?
Yes, because it's, again, outside your employer. It's something other than your employer.
Okay, we've got a call coming in.
Great.
Good afternoon.
Yes, Attorney Keller, how are you?
I'm well, thank you.
That's wonderful. Attorney Wall, I'm watching the show, and just for clarification purposes, I work at Chrysler, and I see supervisors, you know, they unhook safety valves on manual presses or streamline presses to get out more production. So if that safety valve is unhooked to increase the production, and if an employee gets hurt, you're saying that that person can't sue the company?
I'm going to say that as far as work comp is concerned, you're only going to get workers' comp. As far as you filing a grievance, okay, and going through the grievance process with regard to that wouldn't stop you from doing that. But I don't think there's any type of damages other than wage loss and medical if you get hurt if they're trying to do that. Would you
But
agree?
isn't that considered negligence because he took off the safety valve to increase production?
It's definitely negligence. If he's a coworker, your exclusive remedy is workers' comp. I know that doesn't sound like common sense and it doesn't sound fair, but the guy works with you. If it's someone else coming in there, who services the machine that doesn't work for Chrysler, yeah, there's a third party there. If it's a coworker or supervisor, and he doesn't intend to hurt you, I'm still thinking you live in Michigan. That's a work comp issue. It's a good question, though. I'll tell you.
You have to establish that it's a deliberate, intentional, and willful act.
Yes,
It's almost as if your employer is standing in front of you, pointing a gun at you.
right. It's like a criminal act.
Right.
But
Mr.
that's
Walt-
what he did because he was trying to increase the production.
No, that is your subjective determination of what he did. Objectively, he had to intend on hurting you, deliberately intend on hurting you in order to cross over. And that's how far our Supreme Court has gone to erode the rights of injured workers.
Oh, absolutely. I've had people, it's a great question. I've had people killed. I have people that are paralyzed because they're trying to increase production and making things unsafe. This is a coworker or supervisor. It doesn't take it out of the realm of workers' comp, and I don't expect that to make any sense other than insurance companies save money because they're doing business in Michigan and they have a governor that doesn't care.
Would you give this
So as a worker,
person?
I really don't have any rights then. as
You have a right
worker
if you
of-
get hurt. Well, it's dangerous. You can file a grievance to try to, make it safer, but you don't have any right to get any other type of damages from him doing that ridiculousness.
So I couldn't sue him personally then?
I don't think so. He's a coworker.
No, you cannot.
Yeah,
Unless he or she
intense.
intended on injuring you.
Yeah.
I just had a lady call me today where she was upset. She was getting divorced and she was crying on the job. So what happened is her employer, supervisor, grabbed her around the neck and told her she couldn't stand and cry on the job. And another employee assisted the supervisor in carrying her out of the shop. I told her that she could sue those individuals for a deliberate, intentional, and willful act. Now we're going to take a break for a minute, and then we'll be back with more questions.
Thank you.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
You know, I tried to point out to you a little earlier, and I mean you, our audience, that workers' compensation lawyers are very underrated, and they have to have more knowledge than most lawyers because they have to understand not only workers' compensation, but they have to understand Social Security laws, they have to understand automobile no-fault laws, and they have to understand the law of negligence because they're all interrelated. And Peter Wall, I wanted to ask you some questions about the interrelationship between workers' compensation disability payments and Social Security disability.
Sure.
It's a very, very important area. Could you explain the relationship between the two?
Well, you might be entitled to both. Social Security, disability. Number one is for people that have paid into the system, I believe. I'm not a Social Security practitioner, but you are. I think if you're disabled from all work, any job, you might be entitled to Social Security benefits. Whether it's SSI or SSD, I'm sure you can answer that question. When a person gets hurt at work and is disabled from not only the job they got hurt working or earning a wage, they might be entitled to Social Security as well. Some people get both. When it comes as far as into play, as far as me thinking about a Social Security disability claim when someone has work comp, I have to know when a person is going to be qualified for Medicare benefits. And the reason that is if I'm working on a work comp case and I'm trying to resolve a work comp case and a person has Medicare, I am bound by law to take into consideration Medicare's interests. And what does that mean? Have they paid any money for the work-related treatment? Or what does Medicare want as far as a future amount of money to be put in a bank account to use? They will require that before I'm able to resolve a work comp case. So what I try to do is before a person has Medicare, I try to resolve a work comp case because I don't want to put money in a bank account for Medicare.
Well, one of the other problems, however, is if a younger person gets injured, at the bottom of the workers' compensation settlement form, you have to spread out the amount of money that you're receiving in workers' compensation. Is that true?
That's true. We allocate over your life expectancy. So what it looks like is if you're getting a set amount of money, we look at the tables to see how long you're supposed to live, and it looks like if you took your lump sum settlement, by the way, if I'm getting you a settlement, it's tax-free, the lump sum settlement over your life expectancy.
Now that can affect your right to receive Social Security disability.
I think it does because I think it can't exceed a certain number.
And it can also prevent you from receiving SSI if you don't have a wage earning account.
Right.
So in other words, if you settle a workers' compensation case, and I saw one a couple weeks ago settle for $150,000, and the recipient is not entitled to receive Social Security disability. Because of the amount of money she receives, she's precluded from receiving SSI benefits.
Sure.
Because she's got more than $2,000 in assets. So you have to watch what you do when you put these settlements together because you can have a significant impact upon the rights of individuals.
Yes.
Now, one of the other problems is that the big corporations in this state that provide disability coverage or give us as workers the right to buy disability coverage under those disability contracts require that individuals file for Social Security disability. And there's a direct relationship between the two.
Right, because they get a payback if you get granted the benefits. They get money paid back to them. Is that?
That's my point.
Yeah.
But they can also get a payback from workers' comp, can't they?
Absolutely. There might be, as far as robbing Peter to pay Paul, you might be getting those benefits right now, but as far as signing to get those benefits, you promise to pay them back, yes.
And the most interesting situation is if you're drawing disability benefits. Let's say you work at General Motors and you're hurt at work and you're getting paid sick and accident benefits and you're involved in an automobile accident and you receive no-fault benefits and then you receive Social Security. Well, you don't have enough money to pay both funds back, so there's a priority by case law which one you're responsible for paying back first. And it's not your auto insurance company that gets paid first. It's the trust fund from your employer.
Okay.
Because under the laws of ERISA, the Employment Retirement Insurance System, you have to pay back the trust fund first. It's very important to understand these principles.
Sure.
Now, how can people get a hold of you if they want a free consultation?
You can call me. I'm available. My number, again, if you grab a pencil, is area code 248-352-3433. Peter Wall, W-O-L-L. I want to say one more thing. Also, people, when they get hurt at work and they're over the age of 65 years old, a lot of times people are denied benefits because they are working part-time and they're getting Social Security because of their age. I want them to call me if they're not being paid benefits voluntarily. Insurance companies seem to think that they don't have to pay people that are of a certain age because of the Social Security set-offs. That's not true. This is not open season on people that are over the age of 65 that choose to work. And I see that a lot. Oh, you're not entitled to benefits because we get a set-off up to 50% of your work comp because you're getting Social Security due to your age. I want to talk to those people as well.
Okay, well, let me ask you about that. Let's use me as a hypothetical here.
You're in your 50s.
I'm my 50s.
Okay.
My left ear's in my 50s. My right ear is about 24 years older.
Excellent.
Okay, so here I am. I get Social Security. I'm 74 years old. I get hurt in the course of
You
my
look good.
employment.
God bless you.
Yeah, well, I have a good doctor. He
Yeah.
keeps me young. Thank
Okay.
you.
Sure. Okay.
Okay, so I'm 74 years old. I get hurt during the course of my employment.
Sure.
I get Social Security.
Yes.
Can I draw workers' compensation?
You can, but they can claim a set-off. They can take, let's say, over each year over the age of 65, 5% away. They could take up to half. And I don't think that's fair, and I don't understand why it is, but that's the way it is. They could take up to half. But they still got to pay for medical, and it's not open season on people in their 70s that still choose to work. So let me know.
So there's a lot of people who've taken jobs after they retire. And this is real important for you to understand out there if you're listening. If you're drawing Social Security retirement benefits, you can still go out and work.
Yes.
And if you're over the age of 72 and you're working, there's no reduction in your Social Security. So if you're out there and you get a job and you go to work at a pharmacy, or you get a job working at a fast food operation, or you get a job working at the mall as a security guard, and you get hurt during the course of your employment, you get the right to call Peter Wall.
Absolutely. They say, oh, you're too old to get workers' comp. That's a bunch of baloney, and I want to talk to you.
It doesn't matter if you're 72 or 78, you still have a right to make a claim.
If you're 100. Okay. Yeah. God
Well,
bless you if you are.
God bless you, right.
Right. Yes, that's true.
Okay, so it's really important to understand what your rights are.
Yeah.
Now let's just talk about rights for a second, because we're getting in the last 5 minutes of the show.
Yes.
If you have a claim for workers' compensation, what benefits are you entitled to receive in the normal course of a workers' compensation claim in addition to your wage loss benefit?
You're supposed to get 80% of your take-home pay, and you're supposed to get reasonable related medical treatment for that problem that was from the work-related injury, mileage to and from the doctors, possible retraining may apply, possible rehabilitation applies.
So if I'm 28 years old and I'm seriously injured in the course of my employment,
Yeah.
God forbid I lose a hand,
Sure.
I can't function, can I ask my employer to send me to college?
You may be entitled to 2 years of schooling, but that brings forth a good question. If you lose a part of your body, and let's say you don't miss any work, you still get money for the value. The state of Michigan puts a value on body parts if you lose them. It's called a specific loss. So if you lose your hand, you're going to get a lot of money because the hand is worth so much of workers' comp. And yes, you might be entitled to be retraining and to go to school.
But you have to be very careful about a specific loss, because many years ago, I had a case where a fellow made a claim for a specific loss, and the employer refused to pay it because the rumor was that his house was going to be foreclosed on. And he deliberately put his finger in the press.
Wow, that's extreme.
So my point is, if you're guilty of a deliberate and intentional and willful act during the course of your employment, you can be precluded from receiving benefits, can't you?
Yes, sir. You can't intentionally hurt yourself. Yes.
Now, here's the $64 question, and this will be our last one because it's really important. If I'm injured in the course of my employment and I'm off receiving workers' compensation, and I like to smoke marijuana,
I knew you were going there.
and I have to go down to the clinic and have a test to see if my back's hurt, and the clinic says, Mr. Keller, we want a urine sample from you, and I give them a urine sample and I'm dirty. What happens to my workers' comp?
Well, they're going to use it to cut you off. That's why you call me. Because did they give you a test, and was that the reason why you hurt yourself at work because you were positive for drugs? I would maintain that there is some kind of legality as far as a pain treatment, as far as marijuana is concerned. If it had nothing to do with your injury, I'm going to sue them for that.
And you have a right to make a claim for workers' comp.
You have absolutely a right to wait, and I see that a lot these days,
Right, so they'll use any mechanism they can to cut you off workers' comp.
all the time.
And
1
if-
month later, they test you for marijuana, and then they cut you off. Yeah, call me.
So if you got a problem, have a question in workers' comp, call.
Peter Wall, 248-352-3433, WOLL. Thank you.
Thanks for listening today, and please listen in next week. I'm going to have 4 business people on who started their own startups in Detroit. We're going to talk about entrepreneurship, developing your own business, and how to market and go forward in Michigan. Thank you.
Thanks, Mr. Keller.